Please go ahead, we're live.
Okay. Good evening, everyone. Students for the Promotion of International Law Mumbai, in collaboration with Center for Civil Society, is pleased to welcome you to today's virtual campus talk on how liberal is India's constitution with Mr. Prashant Narang. SPIL Mumbai is a student-run committee based in Government Law College, Mumbai. We pride ourselves in being change makers working towards creating awareness and educating students in international law beyond the classroom. We host a variety of events and competitions, including webinars, the judgment deliberation competition, panel discussions, legal article writing competitions, among many others. CCS is India's leading liberal think tank, ranked 81 worldwide by the annual study conducted by Think Tanks and Civil Society program at the University of Pennsylvania. Their work on livelihood, education, and policy training is well renowned. I request all the participants to keep their cameras and microphones off for the duration of the talk. We will be sharing a Slido link on both YouTube and Zoom for participants to ask questions. This virtual campus talk is part of the Indian Liberals Project. I would like to invite Mr. Yazad Judd, Director of CCS Academy, to provide a brief introduction on the project and to introduce our speaker, Mr. Narang.
Am I? Yeah, I'm finally not muted. Thank you once again, Alessandra, and good evening to all. So I'd like to first introduce the Indian Liberals website. IndianLiberals.in is a digital repository of the Indian liberal tradition. It's an initiative of the Center for Civil Society in partnership with the Friedrich Naumann Foundation for Freedom. The website contains periodicals, magazines, podcasts, and various other print and audio resources on liberalism in India, vis-a-vis its social, political, and economic manifestations historically. Please do go ahead and visit it. It's indianliberals.in. Today, I have the pleasure and honor of introducing my colleague Prashant Narang, who is going to be your speaker. Prashant is an entrepreneur turned advocate, and he is one of the few people who has both a great grounding in theory as well as practice of law. He is the Associate Director of Research at CCS, and his most significant contributions include the ease of doing business reforms recommendations and our street vendor compliance index. As a practicing advocate, he has represented street vendors before various courts, right from the municipal magistrate to the Supreme Court. And recently, he submitted his doctoral thesis on the constitutional right to carry on business and trade in India to the government, to the Center for Study of Law and Governance at the Jawaharlal Nehru University. So please join me in welcoming Prashant Narang. Prashant, the floor is all yours.
Thank you, Yasser, for the generous introduction. Okay, let me begin by first deconstructing the words used in the title of the talk. So the title of the talk is How Liberal is India's Constitution. So first of all, let's begin with the word liberal. As we all know, liberal, what we understand by liberalism has four main pillars. The first is market economy, which means there is scope, there is room for private enterprise in the economy. Number two is property rights. So without property rights, there can be no freedom of press. Hayek famously said, and I quote, there can be no freedom of press if the instruments of printing are under government control, no freedom of assembly if the needed rooms are so controlled, no freedom of movement if the means of transport are a government monopoly. So while property rights are crucial for economic development, they are also crucial for all other fundamental rights, all other human rights. Without property rights, you can have no other right. Then third is limited government. So the government role has to be limited to its most essential or core services, right? It shouldn't be in other domains or in other areas of where private parties are there, right? So the role of the government has to be limited to only the essential services. Maybe, for example, like criminal justice, defense, currency, banking, right? Then fourth is And for our purpose, the most important one for today's talk is the rule of law, right? And rule of law, I feel, out of these four, is the least understood pillar of liberalism. Right? And most liberal democracies, they at least vouch, either their constitutions or their polity vouch that they have, they are a rule of law society. So in case of India as well, and you will see in many judgments, judges discussing about principles of rule of law. And it is crucial then when we talk about constitution, we must first understand what is rule of law and whether Indian constitution has elements of rule of law, right? The first component of rule of law is presumption of liberty, right? And I would like to quote Locke here. And Locke had said, liberals, a state of perfect freedom to order their actions as they think fit, without asking leave or depending on the will of any other man. And Mill had argued, and I quote Mill, the burden of proof is supposed to be with those who are against liberty, who contend for any restriction or prohibition. The a priori assumption is in favor of freedom. And this is very important because being law students, you would appreciate that it is just the other way around in our country, in our, before our code. So if you challenge any law for being unconstitutional, if you challenge the constitutionality of any law, the burden lies on the citizen, on the petitioner who challenges the constitutionality of a law, and not on the state, who has restricted the freedom, right? So even though the state may be restricting the liberty, may be contending for a restriction, may be contending for even a prohibition, and yet the burden of proof is always on the petitioner, is always on the person who is challenging the law. And therefore, and the courts have said that expressly, that a law is always presumed to be constitutional unless and until the petitioner shows it to be otherwise, right? And so the citizens have to discharge that burden. Now, one exception, of course, was Sagir Ahmed case in 1955, wherein the court said that in cases of prohibition, in cases of ban, where the implications of a ban or a prohibition are so disproportionately high that it is intuitive for the court to see that many people would be out of jobs, it would lead to closure of many businesses, so on and so forth. There, of course, the burden immediately shifts to the state, to the executive, to show that the restriction is not disproportionate or not unreasonable, right? But otherwise, ordinarily the burden is on the citizen. Unfortunately, even in cases of prohibition, Sagir Ahmed precedent has not been cited quite often. In fact, I think after Sagir Ahmed, maybe once or twice, maybe in a cattle slaughter case, but after that, the precedent has not been carried forward. Not that it has been overruled, it has not been overruled, but it has also not been followed. Okay. So the other tenets of the rule of law are that a law must be general, it must be prospective, it must be predictable, it must be certain, it should be pre-announced, it should be reasonable, and the penalty, so if you breach a pre-announced, predictable, clear rule or a norm, only then a person gets the punishment. This is roughly how we understand the rule of law tenet, right? So whatever rules or norms you have, they should be, first of all, general, prospective, certain, predictable, and pre-announced. There should be a way to know them. And only if you breach, only if someone breaches that rule or norm, then the person should be accorded punishment, and the punishment should be proportionate. Right? Now, where are these components in the Indian Constitution? Right? So first the first thing that I said was general. And what do we mean by general? So general means that law should not be specific of their identities, and this is clearly in our Article 14. Now, similarly, if you look at, for example, Article 20, it doesn't allow for retrospective criminal laws, and it also doesn't allow double jeopardy, right? So that's also a principle of the rule of law. Third thing is about, if you look at Article 19, Article 19.1 has 6 freedoms, and right from Article 19.2 to Article 19.6, these are the provisions that allow the state to promulgate, to enact restrictions, but each one of these provisions uses the word reasonable. So those restrictions must be reasonable. And how do you define reasonableness? So this is very interesting because this has been very contentious in the Indian jurisprudence. But if you see in 1950, the first case on freedom of trade and freedom of profession, trade, business, occupation, the very first case, Chintaman Rao versus State of Madhya Pradesh, had dealt with the question of reasonableness. And the court explained what reasonableness in great detail. So reasonableness is, a choice dictated by reason. And reason means, of course, logic. So you have to ask the question, why are you choosing this policy? And for that matter, I would like to mention here, because a lot many times what happens is when you, being a lawyer, when you challenge a law before the court, sometimes the court says, well, this is policy and we don't entertain policy questions. Now, if you do a simple Control F, with PDF version of Indian Constitution, you will probably not find the word policy. There is no exception to the word policy in the Indian Constitution, right? So any law, of course, it has to be a law, but the law doesn't mean just legislation. Any law, it could be a legislation, statute, it could be subordinate legislation, it could be a GO, notice, circular. You can challenge that, or even an executive action you can challenge before the court of law. And Article 32 guarantees a remedy in case your fundamental right is violated. So any law that you feel it violates a fundamental right of yours, you can challenge that in the court. And Article 32 guarantees a hearing before the Supreme Court. It's not discretionary. Although that doesn't happen, I mean, the court doesn't treat it like that, but the wording of the Constitution is very, very clear, right? So the Supreme Court has to entertain a challenge, and there is no discretion in the Supreme Court to not do that. Okay? So reasonableness and the the court says the reasonableness has to be, first of all, you look at the purpose, you look at the context. But number two, most importantly, and how we understand, how we look at, for example, Article 14. So Article 14 says equality before law. And the judges said that it doesn't mean that, you will treat two unequal as equal. So you can't compare apple and oranges. But of course, you have to show that, you have apple and oranges and not two apples before you, which means that you can categorize, you can have classification, but show that there is classification, show that the two things are different, right? So what we say is intelligible differentia, and there has to be a nexus between the means and the end. But something similar, and this is very interesting because we often think Article 14 and Article 19 differently, right? But if you read Chintaman Rao judgment, the test prescribed for Article 14 is part of Article 19, right? And often in the old judgments, the judgments that were there in 50s and 60s, those judgments don't see multiple reviews, a review under Article 14 separately and then a review under Article 19. So those judgments review an impugned law on Article 19 alone. Why? Because Article 19 is enough to undertake that review. So the first test under Article 19 is also the nexus test. And back in 1950, they are talking about nexus test. They're talking about proportionality test. They're talking about lesser restrictive test, right? And this is exactly now you see in the European jurisprudence, which is called as the proportionality test. Now, proportionality, don't confuse it, because proportionality is one of the components of the word proportionality, the European proportionality test. So proportionality test has 4 parts. One is the purpose of the law, second is the nexus, third is the proportionality per se, and fourth is the balancing test, right? So some of these elements of proportionality test our Supreme Court applied in 1950 in Chintaman Rao. And this is quite significant, right? Because after some time you see in judgments, for example, in late 60 onwards, you don't see the courts applying proportionality, or the Chintaman Rao test in any of his judgment, which is strange because Chintaman Rao has never been overruled. On the other hand, when you look at papers, scholar papers, research papers, journal papers written by other scholars on the issue of standards of review, So even if the paper is written, for example, in the context of Article 15 or 16 or Article 14 or other fundamental rights. So for example, Khetan has written about rigorous standards of review in the context of Article 15, 16 and Article 19(1)(a). And his argument is that rigorous standards of review apply to these articles of the Constitution, to affirmative action, to freedom of speech and expression. And he argues that because these rights are more important, these fundamental rights are more fundamental than other rights, which is strange because our Constitution doesn't have any sort of hierarchy. There is no hierarchy in our Constitution. Nowhere it says that within Article 19, Article 19(1) is more important, or Article 19(1)(g) is lesser important, or Article 15 and 16 are more important than Article 14, right? It doesn't have any sort of that hierarchy. And the word reasonable is being used for all 6 freedom under Article 19 of the Constitution. So this is an important thing to keep in mind. So coming back to the word reasonable, I said the first test was nexus. So there has to be a nexus between the means and end, right? The act objective, what the act wants to, what the law wants to achieve, and how it wants to achieve, there has to be a connection between the two, right? If there is no connection between the two, that means that the law is arbitrary. It seeks to achieve something which it can't achieve. So there is no connection between the two. Then, of course, the court later also in some judgments had evolved the term lesser restrictive alternative. In Chintaman Rao, it doesn't use the exact phrase lesser restrictive alternative, but it meant exactly the same. That when you seek to achieve an aim, what are your different options? And while you choose a particular option, is that option overly excessive? Is that excessive or overly restrictive, right? So 2 or 3 things emerge out of this conclusion. One is that a law should not be arbitrary. It can't be vague and arbitrary, and it can't be excessive, right? And when you say excessive, one way is to compare it to other policy options to achieve the same aim. And the second is also it could be compared to, for example, other alternatives or other policies, right? So there are various ways of looking to find out whether a law is reasonable or not reasonable, right? One could look at whether it has a nexus with its objective or not. So it should not be arbitrary. Whether it's proportionate, which means that it should not be excessive. And the third is that it should be balanced, right? So it should not go overboard, and there has to be some sort of, for example, cost benefit analysis. What it seeks to achieve, the cost of achieving that should not be ridiculous, right? So for example, take an example of, let's say, population, and government often makes a claim that population is a problem and it should be controlled. Although we at CCS don't think so. We don't believe that population is a problem, but hypothetically, let's say if the government wants to come up with a law to control a population, what would be the most efficient way to control a population? Okay. So one would say that government should promote the use of contraceptives, right? So that's one way to control population. However, not the most efficient way. So I would argue the most efficient way of controlling population is genocide, right? Just simply kill people. If people are the problem, you kill people and the problem is solved. And if you see, and in many Supreme Court judgments, you see the logic of judicial review, and the court says, well, this is the purpose. So the court often indulges in purposive review. But if you apply purposive review here, and if you think population control is a legitimate aim, then there is no problem of justifying genocide also. You can justify something as drastic as genocide on by looking at its purpose, right? And this is this is quite shocking. This is quite excessive, because if you can justify genocide by looking at purpose, then you can justify anything and everything, right? And this is what our jurisprudence has been like. If you look at the constitutional cases where the court has indulged in judicial review of impugned laws, this is precisely what the court has done. And I'm afraid that a recent book, this is Rule of Law in India by Harish Narsappa. He has sought to justify judicial review based on purposive interpretation. And I am afraid I don't think so that this view is correct, right? So you have to then move forward and look at the nexus test. But nexus test is also not enough, right? Just because there is a relationship between what you want to achieve and what you between the end and means is not enough, because your means can be excessive, the means can be drastic. So of course, genocide would lead to population control, doesn't justify genocide. So there are many such other examples. So for example, ban on plastic bags, right? Or for that matter, there are many other laws that are promulgated in the interest of environment and so on and so forth, right? So for example, ban on tourists in Rohtang Pass, right? A ban on sand mining. So there are so many bans, and these days there are not just bans by the parliament, there are bans by the executive. So for example, ban on cryptocurrency wasn't a ban by the parliament, it was a ban by the executive. Then there are bans by the National Green Tribunal, NGT. So NGT comes up with general orders and ban certain commercial activities in the interest of the environment, right? Okay, so coming back to the point of the tenets of rule of law in Indian Constitution. So Article 14 is about generality, and it's a central pillar of rule of law in Indian Constitution. Article 19, especially the part of reasonableness, is another tenet of rule of law in the Indian Constitution. Article 20 is another one. Article 21, which is about procedure established by law, or now interpreted as due process. This is another element of the rule of law doctrine, rule of law in the Indian Constitution. Now, this is fine. So what we understand is that there are some elements of rule of law in the Indian Constitution. So where is the problem? Right? That means that the Indian Constitution is very liberal. It is liberal constitution. But is that really a liberal constitution? So now let me take you to chapter 4, part 4 of the Indian Constitution, which is directive principles of the state policy. And let me read Article 36 of the Indian Constitution, directive principles of state policy, Article 36 and Article 37. Article 36 reads, in this part, unless the context otherwise, the state has the same meaning as in part 3 of the Constitution, right? Part 3 of the Constitution, state includes, legislature, state legislature, parliament. It includes, for example, all bodies that are funded, controlled, or where the state or the government has, stake in, and so on and so forth, right? It doesn't include judiciary though. So, and Article 37 reads, application of the principles contained in this part, provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country. And it shall be the duty of the state to apply these principles in making laws. Now, I would like to bring your attention to the words used here. First of all, it says principles. Number two, it says fundamental. And then it says in the governance of the country, right? So, and let's take a look at the principles, so-called principles. So from Article 19 to Article 51, uh, these are some of the directions given. And the first one says certain principles. Article 39, for example, reads certain principles of policy to be followed by a state. The state shall in particular direct its policy towards securing that men and women equally have the right to an adequate means of livelihood. B, that the ownership and control of the material sources are so distributed as best to subserve the common good, right? Then, for example, the operation of the economic system does not result in concentration of wealth. There is equal pay for equal work for both men and women. Health and strength of workers, men and women, and the tender age of children are not abused, and children are not forced by economic necessity to enter avocations unsuited to their age and strength. The equal justice, free legal aid, right to work, living wages for workers, participation of workers in management of industries, uniform civil code, right? Promotion of educational and economic interest of scheduled caste, scheduled tribes, right? Duty of the state to raise the level of nutrition, protection of monuments. So these, first of all, these are these really principles? Or are these aims? Are these some sort of outcomes that we are looking to achieve, right? So principles are something, for example, Article 15, I would argue, is a principle. Article 50 is separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive in the public services of the state, right? This is a principle. But what we just read before this, all those are at some sort of ends that we seek to achieve, right? Those are not principles. Now, if those are ends, then if we follow those ends, then can we have, would we be able to comply with the means, right? Because Hayek, who has written about the rule of law, he gives an example of traffic light, right? And he says that traffic light is, for example, is a system which is identity blind, right? It's a system, it's a game of rules, yeah. So in that, the rules are pretty much fixed for everyone. The traffic light doesn't care about your objective of crossing the light. Where you have to go, it doesn't ask that question and then turn green for you first, then the other party who is standing on the other side of the road, right? There is a pattern to traffic light. So the rules of the game are pretty fixed. The rules of the game are blind to your individual objectives, right? So the means are basically general for everyone. They are not specific to everyone. However, the ends that we see in DPSP, in the directive principle, those ends are specific ends. Those are not general ends. Right? So for example, free legal aid, right? So if the legal aid is free for all, then it is different from saying that it is not specific, then it is general. But if it is free legal aid for some, then it's a specific law, right? Concentration of wealth. The state has to avoid concentration of wealth. But how would you avoid that? You'll have to do redistribution. If you do redistribution by taking away money excessively from some people, right? So for example, imposing very high tax rates on some particular class, then that law is not general, it becomes a specific law, right? Living wage for workers. So then there are a lot of issues with, for example, living wage. How do you determine what is a living wage? What is the formula for living wage? And if it is only for workers, how would you define workers? How would you classify workers? So all the legislation that we have seen And there are there are many such examples of legislation that have been judicially reviewed by the courts. So, for example, rent control laws. So if you look at a rent control law, a good example is Santlal Bharti versus Union of India. In that case, a landlord had challenged the Rent Control Act. And many rent control acts have been, in fact, challenged before the courts on different questions. So one question could be the definition of fair rent. How do you determine fair rent? Right. So there are many laws that impose price controls, that impose quantitative ceilings on licenses, on your permissions, on tariffs. And these laws, it's very difficult to justify these laws on reasonableness because there is no formula. How would you determine a formula? So for example, all these laws that say that how to determine fair rent. So some laws peg the fair rent at a price in 1951, right? So and then you can only increase it by a certain percentage, but this is not how market works, right? Is there a formula how the gold price would appreciate year after year? There is no such formula. Is there a formula how would, for example, the index, the index in the stock market works? There is no such formula, right? So when you limit the market, when you put artificial controls on the markets, it itself, these things become unfair and they become unreasonable because this is not how market works. So as soon as you try to plan, as soon as you indulge in central planning would require controls. And when you promulgate controls, when you put controls, those controls would require more and more discretion. Discretion would require more arbitrariness and vague terms and more power, which is antithetical to rule of law, right? So central planning and rule of law don't go together. And this is the inherent tension in the Indian constitution. So in the Indian constitution, you would see many lawyers saying, and many books also, expressing that there is an inherent tension between part 3 and part 4 of the constitution. But an economist would look at it, a tension between central planning and liberalism, central planning and the rule of law, right? If you wish to have central planning, you cannot have rule of law. And this is very clear in our judgments in last 70 years, right? Because the courts have upheld laws whenever they have been challenged, without doing honest judicial review, without doing proper judicial review. The courts have either indulged in superficial judicial review, meaning they have not applied the test of proportionality. They have not really undertaken a proper reasonable test based on the proportionality test, or they have not done any test at all, right? And there are many such judgments where you will find courts doing a shoddy job with the judicial review and upholding judgments like that. Now, I would like to here also quote Gandhi, what he said about end and means. And there are, so once he said, and I quote Gandhi, "For me, it is enough to know the means. Means and end are convertible terms in my philosophy of life. The means may be likened to a seed, the end to a tree, and there is just the same inviolable connection between their means and the end as there is between the seed and the tree." Right? There's another quote. "They say means are after all means. I would say means are after all everything. As the means, so the end. There is no wall of separation between means and end. Indeed, the Creator has given us control, and that too very limited, over means, none over the end. Realization of the goal is an exact proportion to that of the means. And this is a proposition that admits of no exception, right? So end and means is not a theory which, is, I'm quoting, or rule of law is a theory that, is foreign to us, and Hayek has only talked about it. So end and means is something which Gandhi has also talked about it. Of course, you can achieve your ends, but how do you achieve your ends is very of critical importance, and more so for state, more so for the constitution, right? So while you have these means, the golden triangle, as some scholars have put it, Article 14, Article 19, and 21, and I would also include Article 20 there, right? You have put in too many ends in Chapter 4 of the Constitution, which is Directive Principles of State Policy. I wish there would have been more principles in part 4 of the Constitution. So you have a principle, separation of power. But for example, right to information should have been a principle in part 4 of the Constitution, right? Transparency should have been a value put in part 4 of the Constitution. Subsidiarity, federalism, these are the principles that should have been part 4 of the Indian Constitution. Instead, what we have is, ends. But the question is, how do you achieve those ends, right? So for example, you can still have a liberal democracy, and you see most of the liberal democracies in the world have achieved those ends, right? So for example, inequality may be lesser in some of the Western democracies. In the liberal democracies, the workers may be getting living wages, and indeed the workers get living wages in most Western democracies. Environment and monuments are better protected in liberal democracies than, for example, in India. They have not achieved that through socialism, right? And yet, what they cared for, they basically cared for the means, and the ends were automatically achieved. In India, we are doing exactly the opposite. We are trying to achieve the means, we are trying to achieve the ends. We are focusing too much on the ends, and we are not at the moment caring for whether we are complying with the means or not. In fact, we are violating the means, and in the end, we have nothing, not the means and not even the ends, right? Thank you. Let's have questions.
Thank you very much for this wonderful uh, conversation, Prashant. We have a flurry of questions, and for the audience, for the participants, I just request you that for your questions, we have sent a link in the chat box where you can ask your question. You can also vote for your favorite question. The first question that we have, Prashant, is the inherent problem of the Indian Constitution the fact that it is too big and too detailed, or does its comparative size act as a virtue? What is your opinion on that?
I have heard arguments on both sides. So size, to me, I don't think so. It is a very material fact. I have heard this argument that, because it is too detailed and it is too big, it's a problem, but not necessary. I think the problem lies elsewhere, that the freedoms, our fundamental rights have not been treated as fundamental as they should have been. And of course, the way judiciary has interpreted. So I do believe, what Ambedkar said in his final speech, that a constitution, just putting a constitution is not enough. Even if you have the best constitution written, it's up to the people how finally they take it forward. It's up to the institutions how they take it forward, right? How they interpret it. So even though in the first 10 years you had some very good judgments, but eventually the judiciary distorted the interpretation of the constitution, and look at what happened finally in late 60s and early 70s. So we allowed the parliament to distort and defile our part 3 of the constitution, and part 3 of the constitution was no longer supreme, and it was trampled over so many times. The first amendment, by the way, also in 50s, I mean, the first amendment of 1951, the people who gave us the constitution, even they did not treat it very sacrosanct, because the first amendment itself was the biggest was an attack on the constitution, because it created 9th schedule, and 9th schedule, I would argue that it's a black hole in our constitution, right? This is the biggest assault on the rule of law, because although it was created to justify maybe a couple of laws, to justify and to push the agenda of land distribution, but look at what it has done. There are more than 284 laws now in the 9th schedule of different kinds, and all socialist agenda. But when I say socialism or socialist agenda, it necessarily means that it basically punctures the ideal of rule of law in our constitution. So many laws that are immune from the judicial review, that the judiciary can't look into. Of course, now there are judgments like I.R. Kolo that says that there is some limited judicial review, but that's, I feel, is not enough. It's a farce. So size to me doesn't matter so much. I think what matters is, I think that the logic why they had to keep it big, because they wanted to also entrench the basic architecture of the government. So they were being cautious of how they wanted to entrench certain parts of the polity, and they did that by including that in the constitution. Also, for example, salaries of the constitutional authority, so on and so forth, which was not necessary. Uh, but I don't think so that necessarily has a, and there is another argument. Some people say that, had the constitution been smaller and simpler, it would have been easier for a common person to understand it, and then it would make a difference, that a person would be more inclined towards asserting its rights. So I do see a value, uh, having a simpler constitution that a common person understands it. But to me, I think size-wise, so, if a person knows that part 3 is the most crucial part, he would just go and read through part 3, which is the case, because even most law students or lawyers and even the scholars, don't read the whole of the constitution, because it's not relevant to their, for example, practice or other things. What is relevant to them, they do go through that part, of course. So simplicity matters, not so much the size. Yeah.
Thank you for that, Prashant. The next question, and this is the most upvoted question, it says that how liberal is India's constitution? And if you have to put a number from 1 to 10, where 1 is North Korea and 10 is the US constitution, what number will you give India?
Interesting. So, we do have some constitutional protections. Of course, we are not North Korea, or we are not, uh, other dictatorships. Um, and number 10, I'm not too sure if you would like to give to the United States of America. That's not number 10 either. I would probably argue that United States itself is now a flawed democracy on the democracy index. So it would probably be also not number 10, and probably be maybe 7 or 8. So India would probably be around maybe 4 or 5. There are many institutions. So it's not just the constitution, in its literal term. It's also the constitution, how it has been interpreted, right? So for example, look at how Article 14 has been interpreted, right? And there are conflicting interpretations. So some interpretations, of course, that have been expressly overruled. But even that shows that the same article is being interpreted differently at different points of time, or at the same time by different judges. So for example, you also have dissenting judgments, right? At the same point of time, multiple judges, different judges interpreting a constitutional provision differently. So when we put a number to it, I don't think we can simply assess, evaluate the constitution the way it is written. In that case, we'll have to probably look at in its totality. In totality, the effect is much more on the left side of the ideological spectrum than on the right. The constitution, I would argue, the way it is written is not as socialist as it has been interpreted to be. So maybe literally it was probably 6 or 6.5, but the way it has been interpreted is probably 4, 4.5.
Thank you for that, Prashant. The next question is about the doctrine of basic structure. Do you think that this doctrine is in crisis? And do you also think that there is a relation? What is its relation to liberalism, if at all there is one?
So it depends on whether you want to see the glass empty or glass half full. What is the alternative to basic structure? If the alternative to basic structure is that there should be absolutely no check to what the parliament can amend, then of course basic structure comes as a safeguard. But the other alternative to that would have been that the fundamental rights are supreme, and the parliament should not have been able to alter fundamental rights. At least Article 14, 19, 21, and 20 as I said, because these are the basic principles of the rule of law. And if you tinker with these principles, then nothing remains in the Constitution. So, for example, Article 19, if property rights are gone, right, then what remains in Article 19? Yeah. So this is why, it is important to keep this in mind, that amendability, when we think of amendability of the Constitution, then basic structure is somewhere a compromise situation. It is not the most ideal situation, right? Yeah.
Thank you for that. The next question is by Srinivasan, and he asks, can we as a country reach a stage where we accept freedom of expression in the most absolute sense along the lines of the First Amendment of the US Constitution?
So the question is, the US First Amendment and absolute freedom of speech, is that desirable? Should we have that in Indian Constitution? Is that the question?
Yeah.
So, there are two perspectives. One is, of course, plain and simple, that yes, we should have more liberties, not just freedom of speech and expression, but all 6 liberties that we have in Article 19. And I would say 7th one also, which is now deleted, property rights, that should also be in the fundamental rights chapter in Article 19. So of course they should expand, and there should be almost no grounds of restriction. The other view says about the US Constitution is that US Constitution follows a constructed approach, right? So for example, they do have regulations on certain things, but so you have constructed approach, and the second approach is restricted approach. In case of freedom of speech and expression, yes, it's almost kind of absolute in the US, but as far as other liberties are concerned, right, Indian Constitution follows a restricted approach and not a constructed approach. Let me explain that. So for example, that imagine if our constitution makers had chosen absolute rights, then what could have happened is the judiciary could have interpreted to justify some of the restriction. It could have said, well, this is not even the right, because the definition of right doesn't include this part, right? And in fact, Indian judiciary did that, but there is a criticism to that it was not the correct interpretation, because we don't believe in constructed approach. So nothing is outside, nothing is beyond the purview of these rights. So let me give you an example of Article 19(1)(g), which is freedom of profession, occupation, trade, and business, and ban on alcohol. At different points of time in past 17 years, if there are some rights that have been the most contentious, most litigated rights. One is, of course, cattle slaughter, and the other is alcohol. Education is another one, especially higher education, right? Alcohol is highly contested. There's so many judgments on prohibition or restrictions on alcohol, and how Supreme Court has dealt with it. So Supreme Court, there are two approaches. One is a dissenting approach, but which is the more rational approach that I agree with. I think it was Justice Subba Rao's approach in Krishna Kumar Narula case, where he says that so of course the state can regulate, because we have reasonable restriction approach, but the restriction has to be reasonable. And if there is a ban, then the state has to justify why is there a ban. What is the need to. The problem is, while the state puts a ban on private parties, it runs liquor shops itself, right? So it gives licenses, it earns huge money out of liquor. So when the state earns money, that's fine, but no private party should earn money from liquor. You're getting the point. It looks very immoral if you and I earn money from liquor. But as long as the state earns money from liquor, this is perfectly moral. Right? This is also, how socialism works. So when state does something, that's moral. When private party does, it's immoral. So the court, the alternative approach, which is the majority approach and the prevailing approach, is the court says res extra commercium, which is beyond commerce. Now, this approach is flawed on two counts. A, this is literally flawed because res extra commercium means beyond commerce, meaning that you can't deal in trades. You can't have a trade in commodities that are beyond trade. So, for example, you can't trade in rivers and lakes. You can't trade in air, right? So you can't sell something which is common, which is in public domain, right? So you can't sell and buy lakes. However, the court says you can't trade in liquor because this is res extra commercium. But this is ridiculous. The state trades in liquor. The state gives you license to sell liquor sometimes. The state can give you franchise to sell liquor. The state can itself sell liquor. So how is liquor res extra commercium, right? So these kind of judgments are beyond all rational and logic and make no sense. And there are articles. So there is one scholarly article written by Arvind Datar and I think Swaminathan, Krishna Swaminathan. I can forward the article to Anas and he can forward it to you. But this is the essence of the article, that this res extra commercium approach is inherently flawed, and our fundamental rights are open to all activities. So any activity, every activity, be it education, alcohol, even drugs. So you can challenge. You should be able to challenge the prohibition on any drug, and the state has to then justify. But whereas the US approach is the constructed approach. So the court will say that in the interest of public safety or public morals, so this is the police power doctrine, wherein the state is assumed to have certain police powers, right? So for example, power of taxation, even if it is not in the constitution, the state, it is inherent in a state to be able to tax its people, to tax its citizens, right? So it doesn't need an express provision. This is the interpretation that some people have. I think, although later, even the police power doctrine in the US has been in controversy and has been contested, it has been questioned. Yeah.
Thank you for that, Prashant. And then the next question is, how do you determine if a role is legitimate for government? For instance, space exploration. How do you determine if a role is legitimate for government? For instance, space exploration was a government function. Should government stop funding?
Sure, I get your question. So I think one quick way to look at it is, there are two or three approaches, paradigms through which you can look at it. So one way to look at it is that what people and associations, basically private parties, can do for themselves, the state should not get into. So one question to ask is there any private party that is already doing that kind of work? So for example, running hotels, right? So you have private hotels, you always had private dharamshalas being run by private parties. So was there a good, rationale for the state to open hotels, Hotel Centaur, Hotel Ashoka, right? What was the rationale? Airlines, for example. So Tata was running an airlines, right? What was the rationale for the state to nationalize those airlines? Similarly, banks. What was the rationale of the state to nationalize those banks, take over those banks, right? And then compete with private banks. We have robust private banking. So what is the rationale for the state to compete with them, right? Or for the matter, schools. So people say that state should take care of education because there are so many people, and education also has a positive externality on, in generally in the society. So state should definitely take care of health and education. Yes, but taking care of health and education doesn't mean that it has to provide health and education. It can do that by funding people who need funds to access health and education. It doesn't need to provide health and education and open and, like schools and hospitals. So if we apply this simple test, then at least we can be clear in most things whether state is needed or not needed. So for example, look at civil justice. You have arbitrators, right? Why should there be civil courts? Or if you have civil courts, that's fine, you have to have, but at least allow them to work. The problem is, so what happens is when the state competes with the private party, then there is a conflict of interest. And we at CCS have been doing, working on this, at least in the case of education. So you look at most states have a single department of education that regulates school as well as runs schools. So when it runs schools, it is a competitor to the schools that it regulates. This is inherent conflict of interest because you are regulating your competitor. You are in a advantageous position and you can abuse your power to benefit, the schools that you run, qua the schools that you regulate. And there is so much of evidence that the government department across, all states, they have done that because they have been very harsh to private schools, and not just de facto. I mean, look at de jure. Section 18 and 19 of Right to Education Act puts that expressly. It is what the legislation says, the framework of recognition and enforcement of recognition norms is different for private schools. In fact, there is no recognition requirement for government schools, right? Government schools are deemed to be recognized. This is the biggest conflict of interest, and you have that in almost every sector. Of course, now what the government has done, for example, in telecom sector, that tries to create an autonomous body which becomes the regulator. But I would argue, for example, look at judiciary. Judiciary is also an organ of the state. Has it been impartially reviewing laws, or it has been pro-state? Now there is empirical evidence. There is a paper called Jobs for Justice, as you will easily find it on Google, which argues based on the empirical study that the Supreme Court justices in the most politically salient cases in last 15 years have given judgments in favor of the ruling party, right? So what else evidence do you need? Even the judiciary is not very impartial because it is part of the state. The appointment, I mean, whatever you say, although the pretense is that judiciary is very independent, but in reality it is not. If not the appointment to the Supreme Court, the appointment after the Supreme Court is very much controlled by the executive, right? And that panders their decisions.
Thank you very much for that, Prashant. The next question is a rather interesting one. Is there any way forward for the right to property to make a comeback as a fundamental right?
We all would love to see it back in the Part 3 of the Constitution, and you should start a movement to do that.
Thank you so much.
The other way it could have a comeback is through interpretation, and I don't remember the name of the cases, but I think Justice Ganguly had probably given an interpretation where it said, Article 300A, which is now the constitutional right to property, is also, I think he read it with Article 21 procedure in some sense. So he tried to give a more rigorous interpretation to Article 300A to be able to deal with compensation related cases. I don't exactly remember, that requires further checking. But what I mean to say is that by way of interpretation, that's also possible that it could have a comeback. Yeah.
Thank you. The next question that we have is, could you please talk about the personal laws and the rule of law as mentioned in the Constitution? Aren't they contradicting?
So, to understand personal laws and to understand uniform civil code, we should understand, let's take a look at, for example, the Indian Contract Act. Okay. Now, Contract Act, what it does is is the Contract Act general or specific, right? So Contract Act does not tell you what sort of contract to get into. What will be your terms and conditions in the contract, right? It doesn't say any of that. How many parties can be there to a contract? It doesn't tell you that. You can have multiple parties. All it says is that first thing is you can't have a contract against public policy in India, and then it says what becomes a valid contract, right? How do you get into a contract, right? And then if you breach the contract, if a party to the contract breaches it, then what are the consequences? What are the implications? How would you approach a court of law? And how should the damages be awarded? This is what the Contract Act deals with, right? Now, look at personal laws. A personal law, to the extent, initially they were in the customary domain. So as long as they were in the customary domain, it was probably still okay from the rule of law point of view. But now, after they have been codified, it's a problem, because when the laws are codified, then automatically there is a comparison that how the state deals with personal laws of one community vis-a-vis personal laws of another community, because then you have different personal laws for different communities, although they are based on customs, right? But the state at certain point of time would reform personal laws of one community. So in 1955, it reformed the personal laws of Hindus, but it didn't touch the personal laws of other communities, right? And that also leads to dissatisfaction and accusation of, and these fault lines will always emerge whenever you have specific laws. So whenever you have laws, for example, like in the Indian Constitution, so you have special status for certain states, you have special privileges for certain communities, you have special rights for certain groups based on caste or gender. It would always lead to fault lines in the society. So this is why you need to have, as far as possible, general laws. So I am not saying that general laws would mean that you can't have welfare laws at all. Sometimes you can have identity neutral welfare laws, right? So for example, I'm forgetting the name, the IIM professor who had proposed an alternative to caste-based reservation, that people who have, for example, who are first generation learners, there should be reservation for them. And it goes very well with the data, because the communities who do not have adequate representation, this trait absolutely matches with their sociological profiling. Most of them are first generation learners. So these can be, these sort of innovative solutions can be the way out to have, solutions that are compatible with the rule of law. Yeah.
Thank you.
Sorry, can we go back to your question? What was your question?
Sorry?
What was the question, Anas? Can you hear me, Anas?
Yes. I'm just looking at the question. I'm just following to the question. So the question was about, so the question was about whether rule of law and personal laws, if mentioned in the Constitution, are they contradictory? So does personal laws, if validated by the Constitution, is it contradictory?
Yeah. So I wanted to come to then the issue of Uniform Civil Code. So this is the thing about Uniform Civil Code, so Uniform Civil Code, there is no problem with Uniform Civil Code as long as it is about the form and not about the content. It's not about the substance, right? So if the Uniform Civil Code only prescribes, how do you get into marriage, and how can you, for example, write a will, right? To that extent, Uniform Civil Code is fine. But as soon as tries to tell you that, how many partners you can have, or what would be the gender of your partner, then it's a problem, right? So you can decide the content of your personal laws based on your customs or based on your individual liberty, right? Rather than the state telling you what should be the content. So the problem is who fills that content, right? The community fills that content, or the state fills the content, or whether the individual has the liberty to decide the content of the civil union between two consenting adults. This is the question to answer. and if the individual has the liberty, whether the state will safeguard that liberty or not, right? Because the contracts are safeguarded by the state. If the contract is not respected by the other party, then you do have a forum to go to. Right? It could be an arbitrator, but even the arbitrator award has to be enforced by the state, right? So you need that minimum guarantee by the state to have that enforcement at least.
I'd like to ask one last question. We have a very engaging audience, and I think we have many questions. So would you mind taking one more question?
Sure.
The next question that we have is, do you think that the nexus is given more importance in both lawmaking and enforcing?
Yes, that's right. Because in most in lawmaking and in enforcement, I am saying even in judicial review, nexus is given more importance than anything else. In most judicial review cases also, the court has failed to ask the question of proportionality or other alternatives. It just looks at the link between end and means. It doesn't really goes into evaluating the means. So from public policy point of view, if you see, the legislature, or for that matter, the executive, doesn't take into account the cost benefit analysis, right? There is no system of automatic review. Before making the law, we do have a system of standing committees in the parliament. So sometimes the bill is sent to the standing committee, but the standing committee also takes into account, it basically does consultations. It takes into account what people say about it, but it doesn't, for that matter, takes into account the economic safeguards. So for example, whether the law is pro-competition or anti-competition, right? By the way, we do have a competition regulator. We have a competition act, but we don't have a competition policy, right? This is important. It's very important to appreciate this difference between competition act and competition policy. India doesn't have a competition policy. So the laws are not judged based on whether they are pro-competitive or they are anti-competitive. Conduct of private parties are judged before the Competition Commission, but not the statutes. So this is a problem. So whenever a bill is to be passed, even the standing committee would call people to make representations. But this is also, sort of a democratic safeguard. So any MP or the cabinet who is pushing forward a bill to the parliament, it's already representing the people. What you need is, first of all, some sort of economic cost benefit analysis, and second is some sort of legal safeguard, whether on the constitution and on administrative law, or common law. Is the law good or not? Does the law comply with some basic requirements of administrative law and constitutional law or not? So both on economic safeguards and on legal safeguards, there is no systemic check either at the time of passing the bill, or even after, for that matter, let's say after 3 years or 5 years, there is no review based on these safeguards, right? I think this is a flaw in how we enact our laws and how we review our laws. So there is no system there. The system is absent.
Thank you very much, Prashant. With this, we would like to conclude. I'd request Alessandra to give the vote of thanks.
Hi, Anas. Thank you. We would like to extend our heartfelt thanks to Mr. Prashant Narang for taking time out for us today evening and for an extremely enlightening talk. A big thank you to all the participants who joined us today evening. We hope to see you again in both spills as well as CCS's future events. Do visit the website www.indianliberals.in for further information on the Indian Liberals Project, and follow Spill Mumbai on all our social media platforms to get updates on our events. We request you to fill the feedback form we have sent in the chat. We'll keep the meeting going for a few minutes so you can do that. Thank you all.